My custody trial was only about an hour and 40 minutes long, and at the end of the trial, the judge did decide to give full custody over to my ex-husband, even though my daughter had been primarily living with me her entire life. I am currently preparing to write my brief for the appeal. I'm having to figure out what are the major points I'm wanting to argue in the appeal. The first thing I'm going to focus on is the change of custody requirements. The law does state that in order for a judge to change custody, there needs to be a substantial change in circumstances, needs to show evidence that it is a harm to the child, and needs to be in the child's best interest. So today I'm going to go over the audio again of the trial, and I'm going to cut out the parts where these points are discussed. A lot of this was not discussed in the trial. I'm going to at least try to find what parts of the change of custody criteria does exist, because I know the judge did not review the best interest part. There was no proof that the change in circumstance made any harm to my child. So I'm about to go through that audio, find all of those pieces, put them together, and I'm going to let you guys listen to it.
Time set to address a motion to modify that was filed by Mr. If I'm not mistaken, it's about the mom moving the kids, and that's going to maybe mess up your every weekend that was in the judgment that I signed. So y'all drove up here today. Okay, well, appreciate those efforts, but you know you can change venue to someplace closer to where, so you don't have to drive as far or as far. But you're here now. So, you have the burden of demonstrating why I should change that judgment. Okay?
So far, we've learned that we all think that we're here to modify a parenting plan because I moved, and the judge has informed Mike that he is the one that has the burden of proof. So he has to prove that custody needs to be changed with evidence. I did not violate the parenting plan when I moved, and I was allowed to move. So at this point, I am not in violation of the parenting plan, and in my mind, there's no reason that it meets criteria to change custody.
If it's for just parenting time, you know, what's the best for the child? If it's for changing custody, both have joint custody. I cannot order joint custody. At the end of the day, one of you's going to have custody, and the other one's not. And then that puts the other person kind of disadvantaged, and it kind of eliminates a lot of collaboration about medical decisions and school decisions when one person has custody. If the real issue is about parenting time, you know, I can address that. Obviously, there's been some moves and some changes in maybe. But if you're asking for a change in custody, and I address custody, one of you is going to be the benefactor of that, and the other person's going to be stuck out in the cold.
So keep joint custody, but
It's up to her now. She's filed the response.
I'm still in agreement to keeping joint custody. It seems as though the issue is parenting time.
All right.
When he filed the motion to modify, he did put on there that we have agreed to joint custody, which we had, and he put on there that he wanted physical custody. His request that we just change the parenting schedule. So instead of him having her 3 weekends a month, he wanted me to have her 3 weekends a month, and he would be the primary caregiver. When it comes to my appeal, the judge did mention right here in the beginning that there is a strong criteria in Oregon to switch custody.
We're not going to address custody. Is that okay with you? You're the moving party. I want to make sure it's okay with you.
well, I would still like to have a chance to address my concerns about with the situation.
I understand, but if the two of you agree, that's the only legal way you can keep the joint legal custody. But if you say, no, Judge, I want you to decide, then I have to decide. It's either you or it's her. I can't hear evidence and go, yeah, let's just keep it joint. It's been working out great. It doesn't work that way. So it's up to you. You were the one who filed.
Stop them, I guess. Yeah.
That's your call. Do you want to address custody or just leave it at joint?
I guess custody.
All right.
And that was the moment I realized this was a custody trial. Before that, I just thought that he wanted to swap the parenting time. He was upset about me moving and him having to pay more child support if his parenting time was reduced. I think at this point it would have been necessary for the judge to offer a continuance since it was a complex trial, but he still does not know the complexity of the trial quite yet.
So, two more things before we get started. Do you have any witnesses that are present that you plan on calling besides yourself?
Yes, I got my neighbors.
Okay.
Looking away to my son.
This is when I found out that he had witnesses. I knew that there was nothing that anybody could say that would determine harm to my child.
Nice to meet you. All witnesses are excluded, so you have to step out in the hallway until it's time for you to testify. Burden is on you to demonstrate why I should change those things. It has to be evidence to, again, custody is a different story. But parenting time is just based on what's best for his child. Custody is based on a number of factors that are set by statute. After he's done presenting his evidence, if he has met his burden and I see no change, then I'm not making any changes, except for custody. If he has, then will be your opportunity to present evidence about, okay, we'll change it, but not this way, or everything's on the table. Custody, parenting time, and obviously child support. Just plan on testifying yourself, sir. You're the moving party, so you go first.
Okay.
You plan on testifying yourself?
Yes, sir.
Please stand, raise your right hand to be sworn.
Okay, all right, I just, I wrote a little thing there, asking, so I'm asking for, physical custody of my daughter because it is actually best interest of me because of the living situation Andrea is in with living in an RV.
I pointed that out because after all the confusion about the custody in the beginning, him asking for physical custody and then changing it to sole custody, he then says that he's asking for physical custody.
This is not a stable environment with moving around all the time and living in remote places, sometimes with wildlife and unknown individuals coming around.
He's talking about when we were camping over the summer, and he does say that it's dangerous because she is around wildlife and unknown persons.
So maybe I wasn't clear enough. This is the time to present evidence.
Okay.
So, sworn evidence about what the facts are. I understand what you believe, because I've read your pleadings, I've read your response pleadings. But you're going to have to demonstrate all these things.
Okay. Well, I have pictures, I guess, where she's lived in.
Do you have copies of those pictures? Or just one copy?
Yes, sir. I got copies.
All right. If you would slide a copy of this, then when you look at those pictures, you'll have the opportunity to say, make a legal objection or no objection at all. But you have to review it first before I can review it. Okay.
It ends up taking him a really long time to get the evidence over to me, so parts of this I'm just going to fast forward through it, but it's just him shuffling through papers and handing me stuff.
If you got other exhibits, just might as well pass them on down to her so we can save ourselves all the time. Just here's what I plan on offering exhibits, and she'll look at them and go, yeah, that's fine. Or if there's a couple that she's objecting to, then we can address those. Yes. Oh, wait, no. Yep, wait right there.
After we just heard the judge explain to him that I needed to review the evidence first, he then gets up to go approach the judge with the evidence. That's why the judge is saying, wait, because he goes to hand it to the judge before me.
And what you're looking at, help me out.
It looks like I'm looking at a
There's objections to the statement that's what's called hearsay. It's the only thing the court can receive in trials. It's testimony from people who have personal knowledge. Like, for example, you said you had a picture. I saw where this place was. I saw it, as opposed to, oh, I saw it on the internet. That's what this person knows. You seeing it is evidence. You seeing somebody else taking a picture and putting it on the internet is not evidence. That person has to swear and authenticate, yep, this is exactly what happened, as opposed to, oh, I got this report. And that person's not here to testify that everything was true. So the only court can only consider things that people have personal knowledge of, that they swear, like you have, under oath, to tell the truth.
Okay, remember this part because then in a few minutes he tries to submit some other evidence, some photographs that he got off of the internet and did not take the pictures himself and was not present for the photos. And one of 3 of those photos made it into trial for evidence, even though I objected to all 3.
Next piece of evidence, sir.
Picture of my daughter with her bed where she's living at now.
I have no problem with this piece of evidence.
This picture was taken after my daughter got stung by a bee, and she wanted me to tell her dad about it. So I took a picture of her, sent it to him, and said, Ashlyn wanted you to know that she was stung by a bee. And he's trying to use this as evidence that her bed is too small, and that's what makes me unfit and should lose custody, I guess. I just see it as my daughter has a cute bed that she's very comfortable in, and I'm doing a good co-parenting thing by sending him a picture of the bee sting that she wanted him to know about.
We'll call that response exhibit 101. Proceed.
Do you have another copy for me, Mr.
A copy or a picture of a RV that she's living in currently.
If you got a whole bunch of pictures, why don't you just send them all down to her and she can...
He's telling him again to hand over all the evidence so I can look through it and see if I object to anything, but this is still not all of the evidence. This is only about the first 15 minutes of our hour-and-a-half trial, and so far I have not seen any compelling evidence that custody should be changed. I haven't seen anything proving harm to my daughter, but stick around for the next part and let's keep watching.